Hear ye, hear ye. The Colorado Court of Appeals is now in session. Please be seated.
Good morning. Welcome to Division 2 of the Colorado Court of Appeals. Can you all hear me out there? Okay, thank you. Today, it's my distinct pleasure, I'm John Daly, it's my distinct pleasure to sit with two esteemed jurists in our Colorado judiciary. On my right is Senior Judge Leonard Plank. On my left is Senior Judge Henry Nieto. Both of those judges have mentored many a trial court and appellate court judge, including myself. And I am privileged to be on their panel today looking at these cases. We have two cases on our 9 o'clock docket. And the first case is People v. Jew. Is that the correct pronunciation?
Jew, Your Honor.
Okay, thank you. And then the second case we have on the docket is SR Royalty versus Newfield Production. Are counsel present prepared to proceed in that case?
Yes, Your Honor. Yes, Your Honor.
Thank you. When you came in today, you should have received at the bailiff's desk some written oral argument procedures. Did you have a chance to get those and review those?
Yes, Your Honor. Yes, Your Honor.
Thank you. Okay, I'm asking the counsel in the second case as well. That's okay, you don't need to stand up again, but did you have a chance to review those?
I believe in advance, but not this morning. We'll have a copy.
I wish you will, because when we start our oral arguments, I'm going to ask you if you have any questions on those. Do you have any questions?
No, Your Honor.
Thank you. Thank you. Thank you. Thank you both. Okay, counsel in the second. Okay, I'll ask the second case when it comes up. The shorthand version is when you come to the podium, give us your name and attorney registration number. Remember that our arguments are being live streamed and are also being archived on the judicial website. If you have confidential information such as a minor's name or a sex assault victim's name, please don't disclose it. Please be aware of that it will be public information. Everyone in the audience, I'd ask you to turn off your cell phones or pagers so as not to disrupt the oral arguments in the case. And if we don't have any questions, I think probably we can begin in the first case of People v. Jew.
Good morning. May it please the court, my name is Colleen Kelly, registration number 42502. And I'm joined this morning by co-counsel Jeffrey Wolf, registration 37817, but I'll be making the entirety of the argument this morning. I represent the defendant appellant, if I didn't say Matthew Jew, and for the purposes of oral argument, I'm going to focus on issue number 1 of the brief, but obviously welcome questions about any of the other issues. So the first issue, and also I'd like to try to reserve 4 minutes for rebuttal.
And we hope we can accommodate you. You will be in charge of your own destiny, largely in charge of your own destiny.
Thank you. So the first issue that was raised on appeal is that the trial court erred in denying defendant's motion to compel discovery of the contents of the alleged victim's cell phone. And the facts relevant, we believe, to that issue are as follows. Matthew Jew, the defendant appellant, met Ngun Narangarel in the fall of 2013 when they were both students at the University of Colorado Boulder. They exchanged phone numbers and they went on several dates, by the trial record no more than 5. Not more than a few weeks later, Ms. Narangarel sent Mr. Jew a text, and that text was referred to at trial as the breakup text. And it said something to the effect of, I think it's better to end this now before it goes any further. I want to focus on school. I don't want to be in a relationship, and I'm sorry for wasting your time. But over the course of the next year, Mr. Jew continued to pursue Ms. Narangarel. He would text her and message her and call her without much response, and on a few occasions, he did stop by her home. And over the course of that year, Ms. Narangarel would block and unblock his number from her cell phone.
Counsel, may I interrupt you for just
Yes.
1 second, please? Would you characterize the number of texts that Mr. Jew sent? I believe it's EN. Would you characterize that as in number of maybe in the hundreds?
Close to, Your Honor. But there was some dispute at trial as to how many she received because of this blocking and unblocking of the phone. And of course, at trial, she did concede that when his phone was blocked, she was not receiving those text messages.
Was there any evidence that she received hundreds of text messages?
I don't think that's clear, Your Honor, from trial, how many she actually received.
Okay, I thought the prosecutor had made a comment in closing argument to that effect, but I don't want to interrupt you anymore. Thank you.
And that's fine, Your Honor. So over the course of the next year, and that's 2014, he was at least initiating communications. But by the end of November 14, she did call him, and that is in the record, and they had a 40-minute phone call. And by her testimony, that was her warning him to leave her alone before she called the police. But in fact, he continued to send text messages, and at that time, she was receiving text messages. I don't think that's in dispute. But about 2 months later, and this is January of 2015, she did call the police, and she reported that Mr. Zhu was stalking her. The police spoke to Mr. Zhu, took a statement from him, arrested him, and eventually charged him with the 1 count of stalking that we went to trial on. As part of the investigation, though, what the detectives had done was they approached Ian. Is that how the court prefers me to refer to her?
I would prefer that, and I thank you for that accommodation.
And that's fine, Your Honor. I will attempt to do that.
Thank you.
So the detective, and it was Pacheco from the University of Colorado Police initially, approached her and asked her for permission to first look at the messages in her cell phone and then to download the contents of her cell phone. And what they did after that was go to a different detective who obtained the passcode from EG and in fact downloaded the entire contents of the cell phone. Now, the contents of the cell phone remained in the possession of law enforcement. A defense counsel at trial, and remember there were 2 trials in this case, prior to the first trial, filed a motion. And that was a motion to compel discovery of the entire contents. At some point, however, the prosecution did file a response motion and offered an alternative because of privacy concerns. And the alternative was to conduct an in-camera review.
The prosecution offered that?
The prosecution offered that as an alternative in their motion, in their response motion to the discovery motion. And defense counsel conceded that that might be an appropriate review, to review it for what we really were looking for in that discovery, and that was the communication between EG and her 2 roommates at the time, because it was very clear from discovery and from testimony at trial that the 3 of them had been communicating about Mr. Zhu. And the communication was alerting EG when he had come to the house, her talking back and forth about him trying to contact her. And the only evidence of that communication, or the only actual communication between EG and one of the roommates that we received, was a short exchange. And that exchange was very lighthearted. It contained the phrase LOL, meaning that it was a laughing matter, and joked about perhaps going to the police or perhaps chasing him out of the room with a broom like a barbarian. And so the reason that we believe this material was so, well, this particular evidence was material and therefore required to be discovered under Rule 16 and under Brady v. Maryland is because of that one exchange, that it really indicated the only thing that was in dispute from the defense perspective in this trial. And again, through Mr. Zhu's own statements and through the evidence that presented at trial, the defense wasn't disputing that these things had occurred for the most part. It was conceded that he went to her house and he called her and he contacted her by message. But what the defense focused on in both of the trials was the requirement of the statute that the victim suffer serious emotional distress as a result of the defendant's actions. And we believe that the message exchange was extremely indicative of a lack of emotional distress.
In the record, did defense counsel posit the reasons why they needed these other text messages or other phone records? And if so, can you tell us where?
Absolutely. I think it was discussed extensively in the motion to compel discovery, and there were even attachments. And the attachments were the statements of the roommates explaining how they had that conversation. And I can't say for certain, but I believe that the lighthearted, as we would refer to it, text message exchange was also included in that motion.
Counsel, you said after the motion was filed, the prosecution offered to let them hear the phone conversations?
Well,
Why did your client take advantage of that if there was an offer by the prosecution?
oh, no, Your Honor. I'm sorry, let me clarify that. We filed the motion to compel,
Yes.
and there was a response filed by the prosecution. In that response motion, the prosecution conceded that perhaps the court should conduct an in-camera review to protect any privacy concerns of the alleged victim and only release those messages. And the court declined to do so.
What basis did the court give for declining the in-camera review?
Well, the court, as I understand it, focused on the privacy rights under the Fourth Amendment of the alleged victim and conducted a Spikestra analysis, which we would assert was the incorrect analysis here.
And let me ask you this. Why was there a Fourth Amendment issue to begin with? Usually the Fourth Amendment is enforced against the government, not enforced against private individuals.
And, Your Honor, that's part of the problem in this case, is that the alleged victim never came forward and asserted Fourth Amendment protection. It was the prosecution who asserted that protection and the court who enforced it.
And I understand your point about they may not have standing to do that, but stepping past that, what Fourth Amendment issue really is there? I mean, the Fourth Amendment, is, as I said before, is enforceable against the government. And in this instance, the government was trying to use the Fourth Amendment against the private citizen.
And, Your Honor, I don't think it was a Fourth Amendment issue. That's part of the problem.
I'll ask your opposing counsel that question as well. Thank you, I'm sorry.
Well, so as I said, I think that the error that the court made was really in this Spikestra analysis. And Spikestra obviously, I think, does not, or I apologize, I don't believe that Spikestra applies because of the position. It wasn't that we were trying to issue a subpoena to obtain records from a third party. It was that the records were already in the possession of the prosecutor constructively because they were in the possession of law enforcement. And so really I think it should have been this Rule 16 mandatory disclosure and just a simple Brady analysis where the materials were clearly existing in the possession of law enforcement. It was well documented in discovery that these conversations were taking place, and it certainly was material to the guilt or punishment of Mr. Zhu as our defense, and we stated what our defense was up front in order to attempt to gain access to these records. The defense was that this particular individual did not suffer that serious emotional distress. And I think that it's important to look at this argument of the appellee that this was harmless error. And the argument there is that it was harmless because of the fact that the defense had significant opportunity to cross-examine the alleged victim, e.g., about her emotional state. And I don't think that that's accurate because the defense was allowed to question her and confront her with this one lighthearted text exchange. And that is vastly different from being able to obtain the exchanges between herself and her roommate about how Mr. Zhu affected her emotional state over the course of a year. And really confronting her about how long this went on and how her reaction was never of significant alarm. And so I see that I have 3 minutes and 30 seconds, and I would ask to reserve for rebuttal.
Thank you, counsel.
Thank you.
May it please the court, my name is Erin Grundy, registration number 41271, and I represent the people of the state of Colorado. Today we meet at the intersection of discovery and privacy, where the victim's rights under the Fourth Amendment and the Victim's Rights Amendment compete with the defendant's rights under the Fifth, Sixth, and 14th. And I'll start off by answering Judge Daly's question of how this presents a Fourth Amendment issue at all. And the answer here is that under Rule 16, what is discoverable is information that is in the possession and control of the prosecution and law enforcement. So then it raises a question of, was this information obtained beyond the scope of the victim's consent within the possession and control of law enforcement?
Well, let me ask you, did they give it all back, or did they still have possession or control of the information?
Your Honor, the only information I have on that is that it was held under seal by the trial court.
So where did they get it? Where did the trial court get it?
The trial court got it from the prosecution at the request of the defense to hold under seal.
So once again, the prosecution had the possession of it. So to the extent you're going to argue like, well, the prosecution didn't have possession of it because it was a violation of Fourth Amendment rights, they had possession of it.
Your Honor, I think there's a difference between physical possession and lawful possession, and that's ultimately what we're discussing here.
And the government is in position to argue against itself?
Yes,
Really?
yes.
And okay, give me a case that says the government can assert a Fourth Amendment violation by its investigative arm as a shield to disclosing information.
Your Honor, I think we're in somewhat uncharted waters here, and I acknowledge that in my brief. That's why I think we look to the Rule 17 issues under Spikestra and EG, and we see that a prosecution is empowered and in fact obligated under both the Victim Rights Amendment and the Victim Rights Act to stand in the shoes of the victim, the only semi-party to a criminal case that is not represented, and is in fact the victim was entitled to notice and an opportunity to be heard if any of her privilege records were disclosed.
In Spikestra, was the government asserting a violation of a governmental agency as the grounds for quashing the subpoena?
No, but it was effectively trying to make clear that a defense search warrant does not exist. That's what both Spikestra and EG stand for, that a defense search warrant cannot exist.
And there's no issue about a defense search warrant. The issue is, can the defense see what the government has already seen?
Your Honor, I recognize that there are significant issues in this case and that there are absolutely Fifth, Sixth, and 14th Amendment issues. I think one way to look at this case to make the issues that are very complex, very simple, would simply be to find that in this case, what the victim consented to was disclosed, that was given to the defense. They had an opportunity to cross-examine, and to that extent, the court did not abuse its discretion. Another simple way to answer this very complicated question would be to conclude that the error was harmless beyond a reasonable doubt. And the reason for this is far more than the defense has referenced with this one allegedly lighthearted text message. It's much more than that. It's a year in which the victim did not report to law enforcement. It's a year in which, at various points, she continued to talk to the defendant. The defense also substantially cross-examined her about not only her immigration status, but also her application for a U visa. The credibility attack in this case was substantial. They also had one of the roommates on the stand and discussed with her that she in fact allowed the defendant into their home on at least one occasion and spoke to him during the course of the stalking. So there was substantial information that the defense did, and the jury heard regarding whether the victim was both subjectively in fear of the defendant and whether a reasonable person in the victim's shoes would objectively be in fear of the defendant, which is exactly the type of information the defense was seeking. Because that was before the jury, it was harmless beyond a reasonable doubt. But if this court is inclined to reach the harder question, then I have before you more questions than answers, to be perfectly honest, and that's because I'm not aware of any court in any jurisdiction that has addressed this question.
Well, let me come back to the question that I said I was going to ask you before. Why is this a Fourth Amendment issue even to begin with?
Your Honor, it's a Fourth Amendment issue because we have a question of was this lawfully within the government's possession and control?
How did they get it if she didn't consent?
Your Honor, in this case, what we see from the November 2nd suppression hearing is that the victim said that she would consent to allowing the Boulder County Sheriff's Office to use Celebrate on her phone for the purposes of getting the text messages between herself and the defendant.
But
They
they
didn't,
got, in fact, everything that was on the phone.
yes, and
So
what
they
law,
have all that.
they do, and what law
if there was a
enforcement.
search, it was complete.
Your Honor, it was complete, but then there's a question of seizure. So it's a question of what is search and what is seizure. And this is why technological information under the Fourth Amendment is so different than any type of search or seizure we've seen in the past, which the U.S. Supreme Court recognizes in depth in Riley. If you're looking at a search of a house, which is traditionally the most protected area of an individual, when the police go in under the search warrant, and let's say they're looking for a gun, they go in and they search any of those containers that reasonably contain a gun. They can search drawers, they can search file cabinets, they can search the pantry, they can search the bathroom, but they don't take everything with them. What they do in that search is they look at this information, but they only seize that which is within the scope of the search, either the consensual search or the search under the warrant, where there is particularity and reasonableness, the two things that undermine the purposes of the Fourth Amendment. But in a celebrate search, they seize everything, absolutely everything, despite the fact that the government represented to the victim in this case that the scope of the search, the particularity, and the reason for the search was communication between herself and the defendant.
Let me ask you a question, counsel, about this, because wasn't E.N., didn't she say something to the effect of, when the officer said, I may have to download all of this, and her response was, gee, I'd prefer it not all be used in court, but if it is, it is. Something to that effect?
Not that it would be used in court, Your Honor. There is
What was it-
absolutely no indication.
What was the quote
Your
from
Honor,
her?
what I have is they would download it all, but they were only seeking between herself and the defendant.
I'm asking what her response to the investigator's request
Your Honor,
was.
that's the information I have of her, is that they were only seeking between me and the defendant. And I have that citation in my notes as November 2nd, 2015, page 70, which is the transcript site, not the PDF site. And Your Honor, the indication in this is that what the victim understood had nothing to do with discovery. It had nothing to do that everything on her phone was going to be given to her stalker. What she had, at the time she consented, she's about 22 years old at trial. She's an immigrant. This is her first time being in front of the police. She acknowledges that she was afraid to report, and they say, we need to see your text messages in chronological order, and this is the only way we can do it. She says,
But
okay.
didn't- How are you saying that she didn't consent when she, in fact, allowed them to look at everything? That sounds like consent.
Your Honor, her consent to the scope was based on the particularity, that they were looking for communication between herself and the defendant. She had no understanding of what else would happen or what else would be on her phone.
But she was told that this program would reveal everything on her phone.
She was not. She was not told what Celebrate does, and we don't have information on that November 2nd hearing that even if she was told, that she has any acknowledgement of what that means. There's no sort of written notice. There's no indication that the victim understood. And what we see under Spikestra and EG is that the prosecution can stand in the victim's shoes when you're reaching potentially privileged information, when you're reaching information beyond the scope. And as I acknowledged in my brief, I have not seen this applied in Rule 16.
Let me ask you a question, counsel. I want to go back to the record again. You indicated what they told her. My notes reflect, and I may be wrong, but see if this echoes anywhere for you. According to the detective, the victim said that, quote, she would prefer that it's not, the entire contents of her phone not be admitted into court, but if that was, go ahead.
And Your Honor, I'm sure that your notes are accurate. I did not have that in mind.
Wow.
I'm sure your notes are accurate.
What confidence.
Your Honor, I think in this case, we're really reaching a challenging question, and that is, so even if it's in possession of law enforcement, even if it's in possession of the prosecution, then it's the question of, is this type of information really subject to automatic discovery under Rule 16? And Rule 16 gives us a few other options.
A few other options is right. And I'm glad you actually introduced this. I was going to say, what about an in-camera review, as the prosecution had proposed?
Yes, Your Honor, and I referenced that in my brief, that may be a potential option. One thing that I do want this court to recognize, if you're looking beyond the facts of this case, is as Riley references, the scope of your average smartphone, which at that time was only 64 gigs, this is 2014 for Riley v. California, contains potentially millions of pages of data. When it's contained in a cell phone, in a Cellebrite dump, it's not like social services records. It's not like Martinelli records, where these are actually records prepared by a human and designed for some type of review at some point. This is just basically regurgitated data for potentially millions of pages. So if we ask trial courts to do this as a matter of course, that's certainly something that we need to consider: the effect on the docket, the effect on a defendant's right to speedy trial, and how is this really a workable standard. So I think that in-camera review should really be the unusual case more than the usual case. Then there's a question of other opportunities under Rule 16. One of them is that the trial court can deny discretionary disclosures if there's a substantial risk to any person of physical harm, intimidation, bribery, economic reprisals, unnecessary annoyance, or embarrassment. This may reference certain information contained on a victim's phone. Now, there's a lot of information and privileges implicated that I reference in my brief. Spousal privilege, which could be contained in communications between a victim and her spouse. Clergy privilege, maybe if a person is having a crisis of faith and they choose to communicate electronically with a rabbi or a priest. You get an email from your CPA.
Are those what they'd be looking for in an in-camera review in this case?
Your Honor, we have no idea.
Well,
And
I
part
thought-
of that is we don't know what's on a phone.
No, but I thought that the request was for text messages between Ian and her roommates and phone records about calls between Ian and her roommates.
Your Honor, I
I didn't
believe
think it was about,
It was specifically text messages between Ian and her roommates.
not records of when calls may have been made, things like that?
Your Honor, the reference I have is that it's primarily text messages. I'm sure calls may have been within the scope of some discussions, but several of the motions reference specifically text, which makes sense given that they actually have content and not simply a date. So if the court is inclined to do it, I think it needs to be a very limited scope, but I think it also needs to apply in this case. As a general matter, a defendant needs to make an evidentiary showing of why it is relevant, why it's material, why it's necessary, and a victim needs to be on notice with an opportunity to be heard. We see both the Victims' Rights Act and Victim Rights Amendment allow victims notice anytime potentially privileged information could be disclosed.
And did you argue the Victim Rights Act and Amendment in your brief, counsel?
Yes, Your Honor, I did. I have a page cite here, if the court would like it. Answer brief for the Victim Rights Act, 25 of my answer brief. I argued both the Victim Rights Act and Amendment.
Thank you, counsel.
And specifically in this case, what we're looking at are incredible privacy interests. What Riley v. California talks about is that cell phones in this day and age are essentially what a proverbial visitor from Mars would consider to be an essential part of our anatomy. In Riley, the Supreme Court discusses not only pregnancy and fertility tracking apps, but the most basic and privileged type of confidential communication that can be contained on a person's phone. This should not be the subject of automatic discovery under Rule 16, but should instead be subject to some protections. Now, this may be the unusual case where in-camera review of these records for the limited scope of communication between the victim and her roommates over the particular date range, which in this case would also need to be narrowed to be the dates of the alleged incident, so January of 14 to January of 15, with no additional communication, because any additional communication simply would not be relevant to whether the victim was subjectively or objectively afraid. So that would have to be the limited scope in this case. You could look only at those containers, and I think that's a reasonable way to bring traditional Fourth Amendment case law into this type of technology. Where there's electronic data involved, you look at the containers for the scope of in-camera review that would reasonably contain the type of data that is being searched. So here we'd be looking at text messages, iMessages, maybe the call logs, and that would be the scope that would be reasonable in this case. But again, I want to emphasize how this should not be the general principle, that it's subject to automatic, unfettered discovery under Rule 16 because of the significant probability of disclosing that which is neither relevant, material, and significantly privileged and private that should not be automatically given to defendants without any notice, knowledge, or counsel for the victims in these cases. Can also reach witnesses as well as many other parties. Obviously, in this case, we're looking at the victim, so we have additional constitutional and statutory protections. The people respectfully request that this court affirm the district court's discovery decision because it was within the scope of the victim's consent and it was ultimately harmless beyond a reasonable doubt, even if there was error. However, in the event that this court determines that in-camera review is appropriate, it asks that it be limited to the facts of this case where there was an evidentiary showing and there was also particularity. Thank you.
Your Honors, I think what the questions that Judge Daly was asserting about consent were initial concerns of ours. I think consent really is the threshold issue here, and believe that the court made an error in determining that there wasn't consent. And I would agree that Ms. Narangarel was specifically informed that the entire contents were going to be downloaded and did in fact say, go ahead. And that was evident in the November 2nd, 2015 transcript. And I have that at page 86 and page 87.
Counsel, assuming that she did in fact consent to have everything downloaded, does it automatically follow that everything that on that phone is discoverable?
Well, I don't think that everything on the phone is material. But I don't think that there is automatically a privacy concern when the owner of the material has not asserted it. So while phones are capable of containing medical, education, private information that has other protections statutorily and otherwise, that was never asserted that that information was actually contained on that download.
No, it wasn't. It wasn't asserted that it was actually contained in that download, but the prosecution, standing in the stead of the victim, did assert privacy interests in those records. Did it not?
Yes, Your Honor.
Yeah.
And I think that actually, I view that as a creation of Spikestra. The Spikestra case, I think, significantly deviated from the norm.
Well, let me ask you, how does that happen? You want to have a discovery request to the prosecution, and when the prosecution says we shouldn't have to give it up, then you say, oh, wait, that's a Spikestra request, and it shouldn't be the prosecutor responding. It should be the victim's private counsel. Is that your argument?
I think that's how privacy rights have traditionally been asserted by the person who suspects that their rights are invaded. Yes.
But you want the information from the government. The
Yes.
government cannot respond by saying, we don't have to give it to you. We're not going to give it to you because of an interest, a public interest, though in this instance it may be a particular individual.
And that's why I think the procedure for in-camera review has been established in all of those cases where there is a privacy interest. Again, Jowl for DHS records, Martinelli for the other privilege, the official documents privilege that's statutorily excluded from that automatic discovery. And that's why we conceded that there might be information in there that was privacy protected, health records, education records. So that is why we conceded that an in-camera review would be appropriate. And if I may, in closing, if the court doesn't have any more questions, I think that upholding the trial court's ruling really creates this tip of the scales, where it upholds the privacy interest of an alleged victim over the due process rights of the defendant. And so that's why I'd ask the court to remand, at least for an order of in-camera review, if not for a finding that there was just a significant violation. And I thank the court for your time.
I want to thank counsel for your time. Those were excellent arguments, and they're going to help us resolve the issues in the case. The case will stand submitted, and an opinion will issue in due course, but they were spirited and very good arguments on both sides. And I want to thank you both very much. Thank you. Water, get set up, counsel. Thank you. Now we'll hear the second case of SR Royalty versus Newfield Production. Should be a, there we go, perfect.
May it please the court, counsel. My name is Keith Tooley of the law firm Wellborn, Sullivan, Meck and Tooley, PC, registration number 16243. Today we have an issue regarding an attorney's fees and costs award issued by the court, Denver District Court. The standard of review, of course, is abuse of discretion. But the underlying legal analysis is a matter that for de novo consideration by this court. So I want to begin with the legal analysis regarding the order by the Denver District Court dismissing this case for lack of subject matter jurisdiction. Colorado law is well settled that when oil is in the ground, it's a real property interest. When oil is produced to the surface, it is personal property. It is a commodity. And when that oil is sold, the proceeds of that commodity sale, the money proceeds, are likewise personal property. In this case, my clients are both Colorado companies, formed in Colorado, based in Colorado, who negotiated contracts with Newfield, who then had a substantial presence in Colorado, and the payments were made here in Colorado. The complaint seeks damages, money damages, for past due royalties, overriding royalties. This is my client's share of the sales of the commodity, my client's share of that money.
Does the complaint contain anything else, such as a request to declare or adjust interests in the underlying real estate or the real property interests?
The question is yes and no. The complaint does include a request for an accounting, as many collection cases do, and a request for a declaration of the parties' rights under these contracts. These contracts are an initial area of mutual interest agreement. The parties negotiated and signed here. And the assignments, which are also contracts, enforceable as such, they're part of the oil and gas lease assignment, these interests. Likewise, those we asked for a declaration of my client's interests. We did not ask for any change whatsoever in real property title. There is no request to quiet title. There is no request to change title in any way. There's no request for a lien against these properties. There's no request for a possessory interest in land. There's no claim even for future damages. There's simply no claim in the complaint that affects and is directed towards the real property interest.
Would a declaration of rights under that contract have any effect on ownership or title to land?
Under our complaint, no. It has no effect on ownership or title to land. My clients are satisfied with the title. We think the assignments that were recorded and the instruments that these parties signed are perfect. We have no objection to them. We don't want to change them. We don't want to reform them. We don't want to affect them in any way. The only party who's requested a change in title is Newfield. Newfield asserted counterclaims for reformation in May of 2016 in its initial answer. It requested a specific performance of some new deed with different terms. That's the request of the defendant, not of the plaintiff. We're perfectly satisfied with the record as it stands.
Can the defendant in a lawsuit divest the court of jurisdiction by its counterclaims?
That's a possibility, and I think that's a matter for discretion of the court. How far can the court go? If the court believes that the defendant's actions have turned this into a case that lacks subject matter jurisdiction, then we would suggest to the court That doesn't make the original claim frivolous and groundless. It is an assertion by the defendant that there should be some reformation or some change. Interestingly, the reformation theory has been abandoned by Newfield. They no longer assert it, but they did at the time. So what the court did is it referred to controlling Colorado law, but misconstrued it. The controlling Colorado law, and one, it's recited well in Greinberg v. Waltman. It says, the way in which a dispute concerning an overriding royalty is to be treated by the courts depends on the characterization as real or personal property. The court went on. We conclude that an overriding royalty interest may be characterized as an interest in real property for purposes that affect the land involved, and as a personal property interest for purposes of payments that arise from that interest. The court concluded that at the time each payment was due, it became a debt. This essentially was a collection action. In every collection action for payment, you assert, here's why we should be paid, there was a contract, and we've either not been paid or we've been underpaid. That's the claim here. There was no claim that we should affect the title of the property. Now, the problem with the court's analysis is the court objected and thought it was a change in position on our side, that we identified the existing record that we're satisfied with. We identified the existing title and said our interest in particular wells should be X%, and we have been underpaid, and we have no objection to title. We object to not being paid. The court's analysis was that since we had referred to title, since we had considered it, and the court needs to think about it and interpret it, that somehow that's affecting title to real property. If that were the case, you would never have a payment scenario where you had a personal property claim. The analysis of the court swallows that entire concept. There would be no need to say an overriding royalty interest is a personal property interest for purposes of payment. Now, whether a claim affects real property really falls under Rule 98, a venue statute, of course. The venue rule, 98C, says actions that affect real property shall be tried there in that county. The problem we have in this case is that affects is a verb. And Rule 98 is not jurisdictional, it's merely venue. Affects a verb. The word affect, according to Webster's, means to act upon, to produce a material influence, to alter. According to the American Heritage Dictionary, it is to have an influence on, to bring a change in. We didn't ask to alter real property title. We did not ask to change real property title. Indeed, we objected to going down that path. There are multiple cases in this state where courts have considered royalties and overriding royalty interest payment issues in Colorado courts when the oil or the gas was produced in another state. Those include United Bank of Denver v. Ferris, New Mexico Properties, decided here, Antelope Company v. Mobile, Rocky Mountain, Utah and Wyoming, decided here, Brown v. Standard Oil of Indiana, proceeds from...
Are all these cases cited in your brief, counsel?
Yes, they are, Your Honor.
Thank you.
Proceeds from Wyoming, decided here. A federal court case, Centennial v. Carter, where the contract was for the purchase of 20,000 acres of oil and gas interests in Kansas. The court held that's transitory, not local, could be decided here. And Pierce v. Marland, which regarded a claim to overriding royalty interests arising out of New Mexico land, decided here. The district court compounded its error by dismissing the claims based on the claims and counterclaims of defendants. When it did its analysis in the motion to dismiss, the court said, quote, therefore the court looks to plaintiff's complaint and defendant's counterclaims. Having done so, the court finds that although the contracts at issue were signed in Denver, the parties do business in Colorado, and this court has personal jurisdiction over them, the claims are based on interpretations of ORRIs in land in North Dakota and assignments of interest in land in South, she meant North Dakota. The court could not rule on plaintiff's claims or defendant's counterclaims without affecting title to real property located in a different state. Thus, she concluded the court lacked subject matter jurisdiction. The standard under 16CA1821 is not what the answer or counterclaims say. The standard is, were the claims asserted in the complaint and the relief requested frivolous and groundless? The claims are based on record title, yes, but we asked for no change in record title. We did not ask to affect record title. And the error the court made in the frivolous and groundless holding was taking the allegations by Newfield and the counterclaims that there should be reformation of the instruments and flipping that to a conclusion that there was a frivolous claim by the plaintiffs based on, at least in part by her own language, the reformation claim asserted as a counterclaim by Newfield. The court also had findings on both mitigation, which I would like to address later, and never held a hearing of any sort. No trial, no hearing, no witnesses, no evidence. A request for hearing was made. No hearing was allowed or granted. The court ruled without affording any due process to the plaintiffs. I see I have less than 4 minutes, so I'd like to reserve my time.
Yeah, would you hold the time for a second? But counsel, if you meant that you wish to address mitigation in rebuttal, then I would suggest that if your opposing counsel doesn't raise it, maybe mitigation should not be discussed in rebuttal.
Thank you, so I'll address it briefly, if I may.
Right now?
Yeah.
Okay, put the time back on. Thank you.
The court ruled that the defendant did not timely raise its motion with respect to subject matter jurisdiction. It should have been raised in May of 2016. It was not. In fact, there was an affirmative reformation claim made by the defendant. The mitigation argument or analysis did not follow the roughing case, and we believe that was error as well. I would like to reserve the remainder of my time.
Thank you, counsel.
Thank you.
Very efficiently done.
May it please the court, my name is Tim Byer, registration number 12168, and I'm here representing the appellee and the defendant, which is Newfield Production Company. The trial court ruled it was substantially groundless for appellants to file an action in Colorado affecting interest in real property located in North Dakota based on elementary legal principles of subject matter jurisdiction, and therefore awarded attorney's fees and costs.
Right away, because I've been troubled by this. If this jurisdictional question is so elementary and so obvious that you think the plaintiff should have seen it from the very beginning, why did you not raise the issue until months and months into the litigation if it's that obvious?
Because the first thing that we did was move to disqualify counsel based on what we believe was a conflict of interest, that they shouldn't have been representing the party in the case at all. And so while that was pending, we didn't pursue anything in the case, including file motions to dismiss.
And that was not resolved until after the case, I mean, obviously resolved before it was set for trial, and you didn't file your objection to jurisdiction until after it was set for trial.
Well, we filed our, we filed our motion to dismiss several months later after the resolution of the motion to disqualify issue, and the court found that we should have done that in an overlapping manner, that while we were litigating the question of the conflict of interest and whether counsel should be in the case at all, we could also have been pursuing the motion to dismiss, and that was within the trial court's discretion to so find, and as a result, it rejected any claim for attorney's fees incurred during that period, what it called the delay period, saying that we could have done both at the same time. And I'm sure that that's true, and we don't claim that it was an abuse of discretion for the court to make that decision.
And again, I'm still not clear on why, if you believe the court lacked jurisdiction and it was such an obvious issue, why that wouldn't be the very first thing you raised? Why would you ask the court to rule on anything else if in fact they have no jurisdiction to hear the case?
Well, the trial court said that we should have, and the answer, as I said, Judge Nieto, is that we believe that the threshold question was whether these lawyers should be in the case at all, and we believed that it was clear that they shouldn't be. The court disagreed with us, and once that was resolved, we filed our motion to dismiss and proceeded to litigate the case.
Does a district court have jurisdiction to resolve that issue if it has no jurisdiction over the case?
Yes, I think it would have jurisdiction to resolve a question of whether a counsel should be disqualified in the case before it gets to the questions of whether it has jurisdiction over the subject matter of the case. I think those are two different things.
They are two different things, but normally I think we say, kind of like if a court doesn't have jurisdiction over the case, its orders usually are nullity? No?
No, I don't think a decision to, I think that if the decision was to disqualify counsel, and then the case proceeded with motions to dismiss and other process, the rulings of the court from that point forward would still be rulings of the court. And there's no issue of waiver of subject matter jurisdiction. It can't be waived. The question in this case really, Judge Nieto, is, I think, if we should have raised the issue earlier, then should we be given our attorney's fees for the groundless filing by the plaintiffs during that period? And the court said no, which is what the plaintiffs requested that the court do. And we thought that we should still be awarded our fees for that. We thought that was part of the case. And the judge disagreed, and it was within the court's discretion to be able to do that.
Of course, the first question is it groundless?
That's right, and the court made that finding, and that is a finding that is within the court's discretion to make and is reviewed on an abuse of discretion standard. And while they admit that they did not appeal the issue of the dismissal or the question of whether their claims affect title to real property, they're trying to attack it collaterally in their briefs, and I found it interesting that virtually the entirety of the oral argument was devoted to that question, the underlying question of whether their claims affect title to real property, when they didn't appeal that. The only thing they appealed was the award of attorney's fees and costs.
You're right, but if the legal issue had been meritorious, ultimately, how could it have been frivolous?
Well, that's a decision that the trial court made, and they had the opportunity to present to this court on appeal and elected not to do it. They elected to only appeal the question of the reasonableness of the attorney's fees and whether there was a hearing, whether there needed to be a hearing. They didn't appeal the question of whether the decision was correct and whether the dismissal was correct.
They didn't appeal the decision whether it's correct, but they did appeal the decision whether or not, bringing the case was a frivolous claim, which involves, partially at least, a consideration of the merits of that jurisdictional issue. So they argued they were right, and if they were right, it could not have been frivolous, is their argument.
That is their argument, and as I say, I think in order to be able to pursue an argument that the dismissal was improper, or that their claim was frivolous and groundless, they needed to appeal that question. Otherwise, they're left to appeal the reasonableness of the attorney's fees. They can't collaterally attack an order that they choose not to appeal directly.
But the issue isn't whether they're right, because you don't get attorney fees just because you win.
That's right.
And they could be wrong, and the law of the case, I guess, is that they were wrong.
That's right.
They've not appealed jurisdiction. That doesn't answer the question of whether it was frivolous to bring that claim in the very first instance. And I understood that to be the argument that was made, is that here's why we thought there was jurisdiction. Not that we should somehow reverse that decision of jurisdiction. That's settled. But was it frivolous to bring that based upon this exposition of the law of the position they've taken?
Yes.
That's my understanding.
Right, that is the question, I agree, and the court resolved that. And the review of that decision by the court is under an abuse of discretion standard.
Let me ask you about abuse of discretion standard. Usually there are two components about it. Was the decision reasonable? Was the decision affected at all by a misapplication of the law? As I understand their argument, they're claiming abuse of discretion on the latter part because the question about whether there was a rational argument in fact and in law is something which we could review almost de novo.
Well, that is not what they appealed. That is not what they appealed, Your Honor. And what they are saying is simply that their filing wasn't frivolous because they were correct, yet they didn't appeal that. And so we're left with an abuse of discretion standard was the court as to the question of whether the filing that did affect title to real property, according to the court, that is the law of the case, and that was dismissed, and the propriety of that is not on appeal. They then want to collaterally attack that by saying, well, we were right to file, notwithstanding the fact that the decision, we're not appealing the decision otherwise. And the court, very importantly, Judge Daley, focused on the fact that they had stated multiple times in their pleadings to the court when it was in their interest to do so, that their claims affect interests in real property in North Dakota. And then, when their case has been dismissed because the court has rejected that position, they then come in and say, our claims did not affect interests in real property in North Dakota, so the dismissal was improper and we weren't acting frivolously, and they contradicted themselves. And the court made a point of expressing that in its findings and in its order, pointing out that they made these contradictory positions. And I don't think the court needs to look much further than the statement that they made in response to our motion initially to disqualify them, where they said this case involves matters of record title to real property interests. A clear statement and expression and representation to the court when it was in their interest to take that side of the question. They said in as clear terms as you can possibly state it, that their claims involve interests in real property interests. And then the question of whether an overriding royalty interest is an interest in real property, again, you needn't look no further than their own expression in their motion for partial summary judgment in the trial court, where they said, quote, an overriding royalty interest is an interest in real property. So when it was convenient for them to take that position, that's the position that they took in their pleadings to the court and their representations to the court. And when they then had their case dismissed, and the court was saying, because this affects title to real property, the court lacks jurisdiction to hear it here, you have to bring it in the county where the property is located, they then shifted and took a completely contradictory position, and they're still taking that contradictory position in this court on appeal. The prayer for relief and the distinction in every case that they cite and in the argument that counsel made is in prayer for relief E in their complaint. It's true that they do have claims where they want money, but it is also true that in their prayer for relief, they're seeking a determination of what the interest is, of what the overriding royalty interest is itself. That affects real property. That is a real property interest. An overriding royalty interest is carved out of a working interest in a lease that gives one the right to produce oil and gas out of the ground. That right is expressed in an overriding royalty interest. That is an interest involving real property, and the law is clear on that.
If they, as I understand their position, they're saying that interest is fixed by these agreements that are recorded, and they're not asking to change those. So are they asking this court, Colorado court, to change those interests or simply declare what they are based on the documents?
There was a dispute, and the reason for this lawsuit in the first instance was a dispute between the parties about what the extent of the overrides is, not whether some volume of gas had been produced under undisputed overrides, as the Antelope case, for example, or the Ferris case they rely on, which is a tax redemption issue and had none of their cases involves the creation of or determination of what is the extent of the interest itself. They're all about, if the interest is 1%, how much money do we get? That was part of what they were seeking in this case, to be sure. But the determination that they sought in prayer for relief E was a determination of what is our interest, because Newfields claimed that the interest is X, and SR and Savant, the plaintiffs, claimed that the interest is Y. And the result of that determination will affect how much money are they entitled to under those interests. The determination of the interest, is it what we think it is, or is it what they think it is? That was really at the heart of the case, and it's part of their prayer for relief, and that is the claim that affects title and interest in real property in North Dakota. And they should have known that because they were seeking a determination of what is the extent of the interest, not just what is the money that flows from an undisputed interest, because they were seeking that determination had to be made in the county where the properties are
If
located.
their argument is that they're simply relying on the existence of the documents and asking the court to say, under these documents, this is what our interest is, why is that a frivolous argument saying we're not affecting the title of land? Why is that frivolous?
Because the contract between the parties, for which they were suing for breach, and the assignments that were at issue in the case, where we took the position that the assignments they'd given to themselves were a breach of the contract in terms of what they were allowed to give themselves. They said otherwise. That was at the heart of the dispute in the case. Those documents, the question was, do those documents properly convey to them these interests in real property, or do they not? Our position was that they do not, that they had given themselves interests, that it was a violation of our contract for them to give themselves. They took the position, to the contrary, that those were the interests that they were entitled to. But the point is that the outcome of that determination, were we right or are they right, is a matter that affects interest in overriding royalty interests and the determination of what those interests are, and that is a question of that affects interest in real property. So it was because of that, and those are the findings of the trial court that are reviewed under an abuse of discretion standard, because of that, it was improper to bring the case in Colorado. It was always improper to bring the case in Colorado, and the court made the determination that it was substantially groundless to have brought it here. Now, because the appellants, in just the last couple of moments, addressed the question of mitigation and a hearing, I just want to spend the last minute of my time on that, if it's all right with the court. There is no requirement under Colorado law that a hearing be had on the reasonableness of attorney's fees in every case. And the cases that they cite say that verbatim, and the cases from this court that follow up on that, including the Hendricks case, which we cited, which Judge Daly, you have particular familiarity with, is a case that, and all of the cases say that where a party fails to provide any evidence against the reasonableness of the fees that are sought, and where the moving party does provide evidence, no fact issue is created at which a hearing is necessary. And the court here made a specific finding that a hearing would not be helpful, was not necessary, and then the court proceeded to rule on the issues that were presented to it. And the mitigation issue is really a red herring because we lost that issue. The court completely agreed with the plaintiffs in this case, the appellants here, that because we had not filed earlier, all of the fees during that period, what they called the delay period, were rejected. $117,000 of fees were reduced and cut out because of that. So there's nothing to appeal about mitigation. The court completely agreed with them about that issue. Unless the court has any other questions, that concludes my argument.
Thank you, counsel.
Thank you. These questions have been helpful. There was 10 months of proceedings in this case where Mr. Beyer never raised the issue, his Newfield never raised the issue of subject matter jurisdiction. We had a summary judgment brief in the record. The court ruled that there were questions of fact that needed to be determined and denied us our summary judgment request, never raising the subject matter jurisdiction question. It's apparent that neither counsel nor the court had raised subject matter jurisdiction until the very 11th hour when trial was looming. I think the argument you just heard has things backwards, and I appreciate Judge Nieto's question. The question is not whether you're interpreting instruments of record. Courts do that all the time. You determine what instruments mean. They may be from out of state, may be here. Corporate context, you look at Delaware law and a Delaware corporation. With respect to real property interests, you can review them. And if there's a claim for lack of payment, if you're not changing that title, certainly it can be considered. That always has to be the case for failure to pay royalties or overriding royalties. Always. Because there's always some instrument in the background. The court in the Greinberg v. Waltman case says you look at the characterization in the complaint and the relief requested. What we asked for was payment of our full amount of proceeds that were entitled. We did not ask to affect or change title in any way whatsoever.
Counsel, excuse me.
Yes.
I understood counsel to say in your prayer clause in the complaint, you asked for a change of title.
That's what he said, but that's not what we asked for, Your Honor. What we asked for is,
You asked just for the payment of, you thought that you were not paid all the royalties as a result of the well.
correct, damages, accounting, and a declaration of our contract percentage that were to be paid. We didn't ask to change anything in title. We think that the instruments are clear and plain on their face. We're delighted with the record title, and we don't want to affect it in any way. So we did not ask for a change. I think what counsel did is take the fact that there's a declaration claim at the end and assume it's sweeping and asking for everything. We never, in the body of the complaint, asked for any change in title. Neither did we do so in the relief requested.
What if there is a dispute over those documents as to what is the extent of the interest in the real property or in the royalties? Is that not something that affects the title to the property, and you have to have it resolved?
It may, but it's not what we raised in the complaint or in our relief requested. And again, I think the 13-17-102 asked the court to look, was this a frivolous claim that had no basis at all? Was there no merit to it? And here, obviously, we believe there was merit and there was a good faith basis for it, Your Honor. I see I'm out of time. Thank you all for your patience.
Thank you, counsel. Thank you both for your arguments. Case will stand submitted, and opinion will issue in due course. Thank you both very much. At this point, the court is going to take a short recess because we have to reconfigure the membership of our panel. So if the bailiff will announce a recess. Welcome to Division II of the Colorado Court of Appeals. I'm John Daly. Sitting to my left is Henry Nieto, who was on the prior division or prior panel that was hearing oral arguments today. And on my right is Senior Judge Robert Kopelke, another one of my mentors on this court. We have one case set for 10 o'clock, in re Marriage of De Ronde, is that correct? De Ronde, okay, De Ronde. And, have you, when you came in, did you have a chance to pick up some oral argument procedures from the bailiff?
All did, I did. Yes.
Okay. Had a chance to read them? Have any questions about them?
Nope, actually weeks ago.
Okay. So remember, when you come to the podium, state your name and attorney registration number. Be careful about giving sensitive or confidential information because our arguments are being live streamed and they're also being archived on the judicial website. And I think I would say to the members of the audience, please turn off your pagers or your cell phones so you won't interrupt or disrupt the oral arguments in the case. I think with that, we can probably begin.
May it please the court, my name is Ann Whalen Gill. My registration number is 14160. I represent Jim De Ronde in this case, the appellant. We had a couple issues with the permanent orders in this case. But before I get into that, I'd like to start off by a housekeeping detail. I need to apologize to you for having typos in the two sets of citations in my brief. The Cargill and Rollins case is at 8:43 p.s. I had a typo in that. I also had a typo in my reference to the practitioner's guide. All of the references to the practitioner's guide are in Chapter 7, not Chapter 8. I apologize for the inconvenience. I'd like to address the division of the para pension in this case. As a starting point, you need to keep in the back of your mind that both husband and wife are participants in para, and the agreement at trial was that wife would keep her entire para pension, and there'd be an adjustment made in the division of husband's pension to allow for that so that there could be a single DRO dividing the pension. So there was a lot of discussion and evidence about what was going to be the appropriate fraction for division of a husband's para pension. That eventually was resolved, and a DRO was entered addressing how the payout would be when husband does retire. Our concern is how the fact that the trial court, first of all, required life insurance from husband to protect wife's marital interest in his para pension until such time as he retires. And then it required that rather than continuing the life insurance, which guaranteed her marital interest, the court required husband to select of the three options under para, option 2, which provides a 50% survivor benefit to the named beneficiary, and the trial court required the former wife to be named as the beneficiary for that 50% survivor interest. That was error, it was inequitable, it was an abuse of discretion. The reasons for that is that requiring the option 2 benefit does grant a windfall to the former spouse under all conditions. That as well.
Before you go into that, I'm not clear on your argument concerning the life insurance. The life insurance would only be payable in the event that the husband died.
Correct.
And he could retire, remain alive, and she would have no access to his pension.
No, she does under the DOR. She does have an interest in his pension, and it's a modified Hunt formula. She will start receiving that when he does elect to retire, which could be as early as next year. So she will get under a modified Hunt formula pursuant to the DOR, which is in the record.
Okay.
So we're talking about what happens if a husband predeceases his former wife. Under-
Wasn't there something in the record about what happens if the wife predeceased or the former wife predeceased the husband? Wouldn't there have been a windfall to the husband?
That is part of the discussion of how para works. And she did not cross-appeal in any way, and apparently is satisfied with what the trial court did. That is a possibility. The fact that she is younger than Mr. De Ronde, it's unlikely that she will predecease. So we seem to be focused more narrowly on what happens if Mr. De Ronde predeceases. The expert witness in this case, Fred Ebert, who is well established as a para expert, also wrote the chapter on division of para pensions in the Practitioner's Guide. Says that option 2 would give a windfall of the 50% survivor rate. However, because this is a situation in which each spouse had a para pension, so we did a modification. Mr. Ebert testified that wife's marital interest is only 36%, not 50%, and he calculated the value of that at $730,000. As wife receives payments on the pension under that modified Hunt formula in the DOR, Mr. Ebert testified that those payments should be credited against her $730,000 interest, so that if her interest is guaranteed by life insurance, the amount of life insurance that's required today should over time be decreased because there's a decreasing amount still due to the former wife. And that would, if we go with the life insurance option, neither party gets a windfall, and Mr. De Ronde then can select whatever he wants to do with his para pension in terms of naming a survivor benefit, but he has, by virtue of the life insurance, guaranteed payment of the marital interest to the former wife. And we argue that that is the equitable way to handle this situation. I'd next like to address the division.
Could you take 20 seconds, counsel, and reiterate what you thought would be the preferable way to do this? Because I must have misunderstood it.
I think it's equitable to require Mr. De Ronde to keep life insurance in place. At the end of permanent orders, he was directed to increase the amount of life insurance so that it would guarantee payment of the $730,000, which was calculated to be the wife's marital interest in his pension. As she receives payments from para under the DOR, when Mr. De Ronde does retire, that should be credited against her entire marital share, so that over time, less life insurance should be required. I think that's equitable. It guarantees that she receive her marital share, and it does not give her the windfall, and also leaves Mr. De Ronde free to select any of the 3 para options when he does retire.
Thank you.
The student loans incurred on behalf of the adult children of the parties were also divided in the permanent orders. The permanent orders calculated that the relative income of the parties was 77% to husband, and 23% to wife, and then allocated the student loans in that proportion. That became inequitable when the court then also awarded $3,100 a month in maintenance to wife. There should have been an adjustment to the incomes, because that award of maintenance changed the ratios to 40-60. When the permanent orders allocated the student loans, the court simply said this is in proportion to income. A post-trial motion was filed arguing that there should be an adjustment for the maintenance payments, and the court said it's equitable, it was not a clerical error to change that. I argue to you that it's an abuse of discretion to require the allocation of student loans without consideration of the maintenance payment. That is a substantial change in the income of the parties, and it results in Mr. De Ronde having considerable demands on his income from his net income. If you subtract the maintenance and the student loan payments, he is now at nearly $2,000 a month less than the wife with her imputed income and maintenance. That is inequitable, and he has requested that the student loans be allocated in proportion to their income with consideration of the maintenance awarded to wife, so that it should be a 40-60 division rather than a 23-77 division.
Counsel, is equitable decisions, are they based on mathematical formulas?
No, and mathematical preciseness is not required. I fully recognize that. I'm saying that the change here in awarding maintenance and not looking at that when the loans were allocated has become inequitable because of the impact on the overall property division, which must be equitable. And the result that you have here is to put the former husband in a much worse situation, while wife is in a much better situation. And once again, she is getting a benefit of her maintenance not being considered. The analogy was made was to the child support, which is statutory, and I recognize we're not in a statutory area here when we're allocating debts. But in the calculation of a child support, the award of maintenance is looked at in the finances to determine what's going to be fair and equitable. And I argue that this should be done in terms of the allocation of the student loans here. I'd like to reserve my remaining time for rebuttal.
Good morning. My name is Dennis A. Lacert. Number 13324 is my registration number. I'm here on behalf of the appellee, Ms. Ramona De Ronde, now known as Shower. She's here today. I apologize in advance. I do have a cold, and I'm coughing a little bit, so I'm a little bit muffled, but I'll try to speak up. The first issue is the issue of the life insurance issue. At the time of the divorce, it was a 30-year marriage, and I'm going to argue to the court that there was more than just guaranteeing the PERA account at play here. In the trial management certificate, I asked that the court use maintenance to secure the maintenance obligation. The maintenance obligation was about $430,000 over what ended up being an 11.5-year run after the post-decree motion. We also had the student loan debt that was about $216,000. So there's a very ample reason for the issue of maintenance to be ordered in this case. Now, Fred Ebert, in the trial transcript, the joint expert, at page, I believe it was 52, page 52 to 75, he actually provided quite a bit of expert and enlightening testimony about the PERA pensions and the various options and the survivor annuities, et cetera. He was very concerned, of course, that at the time of the trial, husband was at least about 3 to 5 years away from being able to even do the election. And so with that in mind, that's where the life insurance issue came up. The original amount to equalize, by agreement of the parties, equalizing they both had PERA pensions, was $648,000 with some escalators for interest and things like that. It came up to $730,000. That's in the transcript. So that's where that number came from. I would also ask the court to look at the permanent orders. And the section, it says, until husband makes the election and my client gets her first check, in other words, that 60-day waiting period is gone by and no changes have occurred, until then, life insurance should be in place. And I really don't disagree with the opposing counsel about our argument that technically incremental decreases in life insurance would be appropriate once the actual PERA benefits are flowing. But the word until is a very important word in this case, because it gave the opening to file a motion to modify the life insurance requirements. And I can tell the court, I'm sure you know, that I would raise the issue of the student loans as well as the unpaid maintenance of that part. at that juncture. So I think that the court was, Judge Moss at the trial court level was very correct in ordering the life insurance. He didn't want to have a complete forfeiture of a 30-year PERA account in which my client had an interest in. So I think it was very, very appropriate. As far as the second argument, we talk about equitable. I want to remind the court that at the time of the permitted orders hearing, my client had been laid off from her job, and by agreement of the parties, it was pretty much agreed in the trial court that we imputed an income of $4,000 a month to my client. She has an associate's degree, and some of the equitable other facts are that wasn't put in the briefs is obviously the husband would deduct the $3,100 in maintenance from his income. If he's in a 35% tax bracket, that takes over a little $1,000 a month, in effective dollars. And my client also has to pay maintenance income taxes. She really had very little assets at the time of the divorce. She did get around $75,000 out of the house, the marital home, which was being retained by the husband in this case, by agreement of the parties. So as far as the calculations at 77 and 23, I think the trial court had all the discretion in the world to do that. The judge did that. And I want to remind the court that $4,000 was an imputed income. So most of the income that she had for those calculations was actually not even being earned by my client. Let's see.
What about the option 2 para and the purported windfall?
Okay, I just don't see where there's a big windfall there, Judge, because if the husband died prior to retirement, his actual retirement, whenever he chose to retire, she was simply getting what she bargained for. She bargained for, it was $648,000 was the main number that she needed to get out of his pension. It had 1.7 in or something like that million to make it a 50-50. So the parties agreed on that $648,000. The issue was, how do we secure it? And as Fred Ebert very expertly said in his testimony in that transcript, page 52 to 75 range, he said if he dies before, she's divested.
That's right, but that's the life insurance issue, isn't it?
Yes.
Yeah, but let's not talk about the life insurance issue. They had a separate issue about, essentially requiring an option 2, the 50% ongoing payment of para benefits. Why was that appropriate, not a windfall? Or give the wife a windfall?
Because then she's getting the benefit for which she had bargained for in the event of his death.
She had bargained for option 2?
Yes, that's what we proposed to the judge.
No, that's what you proposed to the
Yes.
judge. Did she agree to it? She said that. Did the
Yes.
husband agree to that?
No,
Okay, so why is option 2 fair?
because the survivor annuity is something that's very important to somebody that has a defined benefit pension plan like PERA. Because if option 1 was chosen and he died, she got nothing. And that's a 30-year marriage account.
Did the DRO give her an interest in his pension regardless of what he did? Is that a separate interest from
Yes.
the option 2 interest?
Yes,
So she has her DOR interest in his pension plus 50% of whatever his remaining interest was?
in the event of his death, then her benefit would go down pursuant to those percentages under option 2.
Go down from what to what?
I think it went down to 50%.
And what was the one that was higher than 50%?
I think there was an 80%. I think that was option 3. We didn't do that. Fred Ebert was very instrumental in testifying in front of Judge Moss that we really needed to have either 2 or 3, because if we didn't, she could be completely netted to 0. I think the life, I think,
Even with the DOR, isn't that a separate pension? Once a DOR is approved and authorized by PERA, isn't that a separate pension for her?
it replaces the first one in the event of his death.
But if he chooses the option 2, then she gets nothing under the DOR?
No, then she gets what she's supposed to get during his life and a 50% interest upon his death. Okay. That's it on number 2. That's what I have to say about that. I didn't know if I had any questions. Number 3, I think this was a harmless error type situation because the statute says that the maintenance will terminate upon the death or remarriage of my client. I know that Judge Moss didn't specifically say that in his permitted orders, but that's the statute. And there's actually a recent case on that. And it's in Williams Estate, and it's 16CA1577. It's actually an estate case that dealt with the termination of maintenance in the context of an estate.
Counsel, had you cited that case to opposing counsel?
No, I just received it, actually.
Well, normally, you're notified ahead of oral arguments. If you've got supplemental authorities, you need to send them out to opposing counsel.
Okay.
So that they have an opportunity to address them at this point.
Okay.
I'm not sure whether, and Ms. Gill, you can determine, but if you would like to address that case in a supplemental letter to the division, the three of us, let's see, today's Tuesday, by Friday you may.
Thank you, Your Honor.
Okay.
And further on in that argument number 3, it appears that the husband is trying to use post-decree facts to try to terminate or modify the maintenance. In page 4, they claims that the wife has entered into a marital-like relationship that reduces the need for support. All those kind of claims, I believe, can be handled under 1410-122 because there's remarriages by the husband, not by the wife. So he's always got that option available to him. But that's about all I had to say. As the 10th Circuit said once, that's refreshing. Any questions? Thank you.
Thank you. I'd like to address the option 2 issue with para. The former wife does receive benefits of her interest in husband's para account when he retires on a monthly basis pursuant to the domestic relations order that is an order of the court, pursuant to a modified Hunt formula. That does not affect the option 2 selection. The trial court ordered husband to select option 2 and name the former wife as the beneficiary when he does retire. And that is our concern. He does have the language about until he makes that selection, life insurance shall stay in place, but he is ordered to make that selection, which is our critical point, is that the selection of option 2 does give a windfall to wife, giving her a 50% survivor benefit, which would be a windfall under any circumstances, and under the facts of this case, her marital interest in his pension is no more than 36%. So option 2 does provide her a benefit. Opposing
How
counsel,
should it have been handled?
I think that the ongoing life insurance, it guarantees that she receive her marital interest when he dies, if she has not already received it pursuant to the domestic relations order. So that life insurance benefit will go to her upon Mr. De Ronde's death, so that protects her interest.
And that had been argued in the trial court?
That's my understanding, yes. And it was certainly something that Mr. Ebert addressed in his testimony, specifically the transcript pages 59 through 62. He goes through the ways of doing this, and then there was further discussion of the life insurance, I believe when Mr. De Ronde was testifying, but I did not make a note of that in my notes.
Did Mr. Ebert say that was the preferable alternative?
I think he was urging it as the way to ensure that no one got a windfall, because depending on which option of the 3, there was a potential for either the plan participant or the former spouse to get a windfall. And he was saying that using life insurance eliminates a windfall to either party.
So his ultimate position was not that option 2 or option 3 was the preferable way to go?
That's my understanding of his testimony, yes.
And there's no authority that you know of that says that the court couldn't give the option 2 order.
I think that it's legally permissible, but I think it's inequitable. As to the student loans, opposing counsel made quite an issue about imputing income to the former spouse. When she left her job at Pinnacle, she was on track to earn almost $90,000 a year. Yet at trial, the court imputed only $4,000 a month to her. She should have been well qualified to get employment at that level, particularly in light of her much higher earnings in the last few years of the marriage. I think that she benefited from a very low imputation because she was unemployed at the time of the hearing. For her to still claim that this is merely imputed income, she's well qualified, years of experience, an associate's degree. She should be able to definitely earn at least the amount that was imputed to her. She also received approximately $75,000 cash when Mr. De Ronde refied the marital home and paid her that amount for her share of the equity in the home. This lady's not destitute. I think that these facts go very strongly to the fact that the allocation of the student loans in proportion to the imputed income and Mr. De Ronde's actual income is inequitable under the facts of this case, and I ask that you will reverse the permanent orders on these issues and remand for an equitable arrangement on the life insurance to guarantee the para, and also for reallocation of the student loans in proportion to the actual financial resources of the parties. Thank you.
Thank you, counsel. The case will stand submitted. An opinion will issue in due course. I thank you for your arguments. We are now finished with this morning's business. The court will be in recess, and the bailiff shall so announce.
All rise.